Good evening, everyone. I welcome each one of you to our Advocate on Record Aspirants Academy. This is our 74th lecture series. We have gathered here to discuss about a very important topic related to AOR examination. Before that, it is our regular practice that we recite preamble of the Constitution of India with a sense of commitment and sentiment, because we strongly believe preamble our goal, preamble our soul. So I request each one of you to recite preamble of the Constitution of India along with me. We, the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and to secure to all its citizens justice, social, economic, and political liberty of thought, expression, belief, faith, and worship, equality of status and of opportunity, and to promote among them all fraternity, assuring the dignity of the individual and the unity and integrity of the nation. In our Constituent Assembly, this 26th day of November 1949, do hereby adopt, enact, and give to ourselves this Constitution. Thank you so much, dear friends. So, keeping the lecture number 71, 72, and 73 as a guiding light, let me take you to the relevant portions in the judgment, and let us understand how it is being explored by the honorable judges. It is very easy to ask the question, and even it is very easy to arrive at the conclusion. But how do you justify your conclusion? That is most important. Because the Honorable Supreme Court laying down a law, and they are upholding or striking down the constitutional provisions, it should be supported with reasons. So let us ask what are the questions that they have framed and how they are exploring to answer those questions. It is beautiful, dear friends. When you take it as a burden, it remains as a burden. When you take it that this is a platform where we can study ourselves, so when you are doing it, when you are going to read a leading case, it is implicit that you are going to be a leading lawyer. It is not a leading case. It is you are going to lead. Because one who knows the provisions, interpretations, he is going to be a leading lawyer. So, one of our known staffs, they have said, we people have degrees, that is Saraswati. But Lakshmi will follow Saraswati. Everybody is interested in earning. But before that, everybody forgets to put L first. Learning. Once learning is there, definitely earning will come. That is why learning is first, and then it continues with earning. Now let us understand this question, dear friends, how it is being evolved. Number 1, I am reading SEC judgment, para number 81.1. Whether the requirements of disclosure of information about candidates can be extended to political parties. Because previously, Honorable Supreme Court has held right to know the candidate, right to know the criminal antecedents, right to know their assets or fundamental rights. Now, can we extend to the political parties also? That is the first question. If the answer to A above in the affirmative, that means yes. If the answer is yes, whether information, now they are coming to the electoral bond, whether information on the funding of political parties is essential for exercising choice on voting. When we are going to reveal the contributions, does it make the voter to take an informed decision to whom to vote, whom not to vote? So this is the issue. Now let me read further, dear friends. Now they are going to explore. They are taking to the political party. So the question, beautiful question is, how do we we are talking about our rights, dear friends. Our rights. How do we correlate ourselves with a party, political party? For example, in Tamil Nadu, the two major parties, AIADMK and DMK. The citizens or the people there, they identify themselves with political party symbol. Symbol is most important. When leader goes, the following leaders will fight for the symbol. Why? Because it is well registered in the minds of the people from generation to generation that two leaves means it belongs to AIADMK. Rising sun means it belongs to DMK. Congress means hand. BJP means lotus. So that is how they identify people. They identify with the political symbols. So how much it is important? There was a reference at para 89. The reference was with reference to Gayatri Devi. They have referred to an autobiography. She was a Maharani of Jaipur and she was contesting in the election. I will read out that relevant para. Before that, let me say, what was the symbol allocated to her? Star. Star symbol was allocated to Maharani. But the competitors, the other candidates, they were allocated with horse, with a rider. And some of the other candidates were allocated with sun, symbol of sun. And repeatedly, Maharani and their team, because at that time it was in the year 1951, literacy rate in India was very, very low. They refer to 18.33 only literacy rate. So remaining people were completely not aware what is the political party, how is the election. 1951, the first general election. So Gayatri Devi went and met the people, village people, and said, see, I am going to contest in the star symbol. Please put your vote in the star symbol. And it was, she has written, Maharani has written by saying, it was frustrating to canvass that I belong to this symbol because nobody could understand. Reason is they were having an impression, Rani means she rides a horse, therefore a horse with a rider, that symbol might belong to Rani. So they were thinking in their own ways. And there was one symbol, flower. Rani means it's a symbol of flower. So our Rani will stand only in the symbol of flower. They thought like that. And some of the people, they thought, star belonged to Maharani. There is a sun is also there. That means it belonged to Maharaja. So we will vote for Maharani and Maharajas. Sun as well as star. It becomes invalid vote. So how people identified themselves with political symbols? Beautifully extracted. Let me take you to the relevant portion, dear friends. Gayatri Devi, the third Maharani. I am reading para 89 of SEC. The third Maharani consort of Jaipur, who was later set up as a candidate by the Swatantra party, recalls in her autobiography that a team spent hours trying to persuade the voters that they had to vote for the symbol star, which was the symbol of the Swatantra party, and not a symbol showing a horse and a rider, because she also rode a horse. In inverted commas, since most of India is illiterate, at the polls people vote according to a visual symbol of their party. Swatantra party had a star. Maybe all my other helpers and I spent endless frustrating hours trying to instruct the women about voting for the star. On the ballot sheet, we said over and over again, this is where the Maharani's name will appear and next to it will be a star. But it was not simple as that. They noticed a symbol showing a horse and a rider. Agree with each other that Maharani rides, so that must be her symbol. Repeatedly we said, no, that's not the right one. Then they caught the sight of the emblem of a flower, of the flower of Jaipur. Who else could it mean but the Maharani? No, 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 not the flower. All right, the star. Yes, that seems appropriate for the Maharani. But look here is the sun. So if the Maharani is a star, then the sun must certainly mean the Maharaja. We will vote for both. We will vote for both. Immediately, the vote would have been invalidated. Even up to the final day, Baby and I were far from sure that we have managed to get our points across. So, this is how the people of India were in 1951, dear friends. Now, taking it forward, see how people are knowing the party with their symbols. Political symbols are very important. Thereafter, let me take you to the relevant portion. Para 97. In summation, a political party, now they are saying a political party is a relevant political unit in the democratic electoral process in India for the following three reasons. Why it is important? Voters associate voting with political parties because of the centrality of symbols in the electoral process. Symbol is most important. The next is the form of government where the executive is chosen from the legislature based on political party or coalition of political parties which has secured the majority. Who comes to the government? Who forms the government? Who gets the majority votes? C. The prominence accorded to political parties by the 10th schedule to the constitution. So this message is how political party plays a vital role, their symbols play a vital role with respect to the voters are concerned. Now the next question, the essentiality of information about political funding for the effective exercise of the choice of voting, that is the heading. So para 98, dear friends, in ADR and PUCL, these were the precedent cases. This court held that, Supreme Court, Honorable Supreme Court has held already that a voter has a right to information. The voter has a right to information which is essential for them to exercise their freedom to vote. In the previous section, we have concluded that political parties are a relevant political unit. Thus, the observations of this court in PUCL and ADR on the right to information about a candidate contesting elections is also applicable. Law is being laid down, dear friends, is also applicable to political parties. The issue whether information about the funding received by political parties is essential for an informed voter must be answered in the context of core tenets of electoral democracy. The preamble to the constitution resolves to constitute a social, economic and politically just society where there is equality of status and of opportunity. The discourse which has emanated within and outside the courts is often restricted to the ideals of social and economic justice and rarely includes political inequality. So far they have referred to that right to information about the candidate includes the political party also. And justice means social justice, economic justice and political justice. Let us see how the political inequality is being played in this case. So they are testing with reference to the preamble of the constitution. See how now they are checking, they are going to test how the contribution made by the companies, how do they get access to the power corridors, because power and money most important in politics is concerned. So what they are saying is when a company is giving contribution, donations to a political party, the political party offers them a seat at the table. That is the first access. Then they have easy access to the legislators. And in exchange, what is the company getting out of the contribution? Even the government may make a change in the policy to satisfy that company. Even they may give license to the company for several years. So this is what they are getting in consideration. So this is what they are talking about, economic inequality. See, economic inequality leads to differing levels of political engagement because of the deep association between money and politics. At a primary level, political contributions, so once contributions are made by X company, what do they get out of it? Beautifully explained. At a primary level, a political contributions given a seat at the table to the contributor. That is, it enhances access to the legislators. This access also translates into influence over policy making. Company has given some amount to the political party. In return, the political party will make changes according to satisfy the company. This is what they are saying. An economically affluent person has a higher ability to make financial contributions to political parties, and there is a legitimate possibility that financial contribution to a political party would lead to quid pro quo arrangements because of close nexus between money and politics. Quid pro quo arrangements could be in the form of introducing a political policy change or granting a license to the contributor. The money that is contributed could not only influence electoral outcomes but also policies, particularly because contributions are not merely limited to the campaign or pre-campaign period. Financial contributions could be made even after a political party or coalition of parties form the government. The possibility of a quid pro quo arrangements in such situations is even higher. Information about political funding would enable a voter to assess. Now they are coming to the voter's right. Information about political funding would enable a voter to assess if there is a correlation between a policy making and financial contributions. These are all the important lines, dear friends. So once the contribution made by a company is in the public domain, and if you understand how much the political party has also received, and government policy will always be in the domain, public domain. So as a voter, you can understand, oh, this much amount was given to a particular party. In consideration, this was a policy change in favoring that company. So therefore, you can have an informed decision to cast a vote or not to cast a vote. Now the second question is, now they have extended right to know about not only the candidates but also about the party, and this is also information, very important information to exercise a right to vote. Now the next question is whether the infringement of the right to information of the voter is justified. Now they have come to the conclusion 19(1)(a) is violated. But we all know that 19(1)(a) is not an absolute right. It is subject to reasonable restrictions. Whether it is justifiable, whether will it fall under the reasonable restrictions or not, by not disclosing how much their contributions made and how much political party received, will it fall under reasonable restriction or not? That is the question. So how to give the answer to this question? The answer is proportionality standard. Dear AOR aspirants, this is very important. Tomorrow in the examination they might ask, please explain proportionality standard test for 5 marks, or explain with leading cases 10 marks. So very important. So how are you going to test the validity of electoral bond scheme, whether does it infringe 19(1)(a)? If it infringes, whether it is justified, will it fall under reasonable restriction? The test is proportionality standard test. What is the test is about? 4 points, dear friends. Please note down these stages, 4 stages. First stage is legitimate goal stage. First stage is legitimate goal stage. Number 2, second stage is suitability. Suitability or OR rational connection stage. See how the Honorable Supreme Court has come out with this test by splitting each and everything, dear friends, for us. Very difficult to write the judgment. Very easy to read the judgment. Very difficult to cook the food. But it is very easy to eat the cooked food. But now we are finding it difficult even to eat also. This is going to give us life. Let us give life to these words by understanding it clearly. Whenever you do, start with a prayer. My Lord, to Almighty, I am in dark. I am not that intelligent as that of others, but I am a hard worker. I want to learn. Please shower me light. Give me light. Definitely your prayer will be answered. God will definitely guide you and will make you understand, provided that your heart, mind and soul strives for excellence. Father Almighty, always ready to help us, but we are running away from our Father. Father is running behind us, but we are running faster than the Father. So that is the problem. Remember our Father, our own parents also, Almighty also. In Tamil they say, Avvayaru, a poet, 3,000 years back. First lesson taught in our school days, first standard. Annayum Pidavum Munneri Deivam. What does it mean? Mother and father are visible gods. They are the visible God. We cannot talk to Almighty directly. But I have saved my mom's number as God, G-O-D. So whenever my mother calls, it displays as G-O-D, God. So I talk to my God. Who is God? Who has created us is the God. She has created us. Therefore, let us respect mother. When they are living, it is not after their life putting flowers and everything. When they are living, we should ask them with respect. Parents should be respected. Only then your child will see. My father, even when my father's mother was alive, my father used to keep the mother's photo in Almira, and he always worshipped the mother, living mother. We have seen that during our childhood, and we started following it. My father did not tell me to respect the mother. He respected. Automatically, I imbibed that quality of respect. Don't preach. Practice. You will automatically get it. So let us respect womanhood, motherhood. Let us respect our parents. Let us respect everyone, dear friends. That is what the preamble also says. Fraternity, assuring the dignity of the individual. Let us respect human as a human. That is most important. Now come to this point. The second point is suitability or rational connection stage. The third stage is necessity stage. Necessity stage. Fourth stage is balancing stage. Balancing stage. So these are all the four stages under which the Honorable Supreme Court has asked a question whether 19(1)(a) is infringed, but infringement, is it justified or not? So what is this test, dear friends? They have beautifully explained. What is the first test? legitimate goal stage. What does it mean? The measure restricting a right must have a legitimate goal. It means, according to Union of India, what is their submission with respect to electoral bond scheme? My lords, it is full of black money. In order to curb black money, we are bringing electoral bond scheme. Legitimate goal, well appreciated. It's a legitimate goal. Every money should be accounted. Unaccounted money is a black money. So through this electoral bond scheme, even unaccounted money will be accounted. Therefore, we have a noble idea, noble thought. In order to curb black money, we have introduced electoral bond scheme. Fine. Legitimate goal is good. In order to curb black money. Number two, what is the next stage? The measure must be a suitable means for furthering the goal. So in order to curb black money, what is this step that you are taking? The second step is we are introducing electoral bond scheme that will end the black money. That is what they have said. Suitability or rational connection stage. Now the third stage is, this is where our judicial mind is being applied. The third stage is necessity stage. Whether electoral bond scheme alone is the only method, is it necessity, or do we have any other method to curb black money? The necessity stage is, how do you say it is a necessity stage? This is beautiful. When you are introducing a scheme like electoral bond scheme, it should have a least restrictive and equally effective. That means it should not impact on the fundamental rights of the people. It should have a least restriction but equally effective. By bringing the electoral bond scheme, is it necessity, or do we have any other method to curb black money? That is the third stage. The fourth stage is balancing. What sort of balancing we are talking about, dear friends? Justice, scale of justice is between the truth and falsehood. So here the balancing is, the measure must not have a disproportionate impact on the right holder. Right holder is, they are talking about valuable voter rights. So the measure must not have a disproportionate impact. You are completely making the voter unaware about the entire transaction. You are keeping the voter in dark. So it is disproportionate. So that is balancing. How? This is where the balancing has to take place. Whether electoral bond scheme is proportionate or disproportionate to the fundamental rights. So balancing is there. This is the test. These are all the four stages under which whether 19(1)(a) restriction or violation is justified or not. This is a test. So how they are going now? Let us see, dear friends. First aspect, they have said we are curbing black money. In order to say this, we are curbing black money. Fine. What else? Second aspect is, I am reading para 129, alternative method. The third stage, necessity stage. Whether is it only necessity stage? The answer is no. Para 129. When these three methods of political contributions, electronic transfer, other than electoral bonds, electronic transfer, you just send it through GPay or electronic transfer, any mobile banking, internet banking, it will be accounted. So when the method like electronic transfer, other than electoral bonds, or there is under income tax side, there is a provision with respect to electoral trust. So there you can contribute to the electoral trust also. That is one way. And electoral bonds are placed on a continuum. Transfer through electronic means other than electoral bonds would be placed on one end, and electoral bonds would be placed on the other end. A voter would receive complete information about contributions made above 20,000 to a political party in the case of electronic transfer, made directly to a political party other than through electoral bonds. So, by discussing everything, this is not the only method in order to curb money. There are different methods. So, therefore, don't use this. Ultimately, what they have found at para 134, necessity stage, in necessity stage, electoral bond failed. Para 134 is important. Based on the above discussion, we conclude that the electoral bond scheme does not fulfill the least restrictive means test. Least restrictive means test. The electoral bond scheme is not the only means, that means it is not the only stage, necessity stage, means for curbing black money in electoral finance. There are other alternatives which substantially fulfill the purpose and impact the right to information minimally when compared to the impact of electoral bonds on the right to information. So, therefore, necessity stage, that electoral bond scheme alone is not enough. There are other methods are also there. So, don't adopt this. Third stage, electoral bond failed. Now, the next stage, balancing. That is, they are talking about donors' privacy. Privacy or privacy. In Justice Puttaswamy case, the Honorable Supreme Court has held categorically right to privacy. Whether right to privacy includes right to information privacy. This argument was made even before the Honorable Supreme Court by saying right to know the candidate. So the political party candidate, they have said, why should I disclose my criminal antecedents for the voters? Why should I disclose my own assets? How many houses I have? How much annual income I have? Why should I disclose to the public? Because this is my privacy. So it will violate. So that was their submission, dear friends. But Honorable Supreme Court has held, yes, we appreciate you have a right to privacy. But let us compare your right to privacy with 19(1)(a). Here an individual claiming that I have a right to privacy. Here the whole Indians asking for in the national interest, in the public interest, saying that let us know our own leaders. Let us know who are they contesting. What is their qualification? Is there any criminal background? So can you claim privacy over 19(1)(a)? The answer is no. When we are trying to balance both 19(1)(a) on one hand, 21 on the other hand, 19(1)(a) outweighs Article 21 right to privacy. Public interest is most important. Nation first, public interest first. They should know how much party is receiving. So right to privacy, that argument was denied. Further, they have said information privacy of financial contributions to political parties. Now, just now I have said privacy vis-a-vis political party. Balancing double standard test is also applied. So, what is the test? Para 152. What is the double standard test? We have seen proportionality test. Let me read para 151 and 152. Very crucial. This is heart and soul of the judgment. The judicial approach, how do you balance both the rights? On one, because Constitution provides this right to privacy also, right to information also. How the Honorable Supreme Court has to balance both? Which right outweighs the other right? Let us see. This is the standard test. The judicial approach towards balancing fundamental rights has evolved over the course of years. Courts have used the collective interest or the public interest standard, the single opportunity standard, the single proportionality standard, and the double proportionality standard to balance the competing interest of fundamental rights. Before the proportionality standard was employed to test the validity of justification for the infringement of fundamental rights, courts balanced conflicting fundamental rights by according prominence to one fundamental right over the other. Based on what? Based on public interest. Very important. In the first modality, the court, while identifying the fundamental rights in conflict, circumscribed one of the fundamental rights in question such that there was no real conflict between the rights. The court, while circumscribing the right, undertook the exercise of weighing the relative constitutional values of the right based on public interest. When two rights are in conflict, which will prevail over the other? Let me give a very simple example, dear friends. An individual owning a land, he is the property, he is the owner of that property. But the government wants to acquire the land for constructing a metro bridge. So it was acquired. Owner says, it is my constitutional right. It violates my constitutional right, don't acquire. But the principle is public interest will always prevail over the private interest. You may be the owner. Government will compensate your money. Compensate by giving money, and then you can acquire. You can purchase the other property. But this property is necessary because it is going to benefit millions of people. So therefore you better vacate. Similarly, comparing here Indians who have voted to a political party and which form the government, and the people want to know how much you are receiving. In consideration, what is the policy change? So this is what we wanted to know as a voter. There should be a transparency in the government. Therefore, only when there is a transparency, the citizens of this country can make the government accountable through court of law. So therefore, the double standard test is based on the public interest. Now, yes sir, para 152, 151 and 152 both. Now para 163, with this I will conclude, and remaining things we will continue in the next lecture. Para 163, based on the above discussion, they have discussed many aspects, but what is the important essence is this. Para 163, based on the above discussion, the standard which must be followed by courts to balance the conflict between two fundamental rights. Dear friends, in AOR examination, they might ask, how do you balance the two fundamental rights? Very essential. Apart from AOR examination, even as a student of law, as a practitioner of law in the apex court, we should understand this. 4 questions they are asking, dear friends, to balance, how to balance two fundamental rights. The first question is, does the Constitution creates a hierarchy between the rights in conflict? Does the Constitution creates a hierarchy between the rights in the conflict? If yes, then the right which has been granted a higher status will prevail over the other rights involved. If not, the following standard must be employed from the perspective of both the rights where right A and B, rights A and B are in conflict. Because 21 right to privacy also falls under part 3. 19(1)(a) falls under part 3. Therefore, Constitution did not make any difference. If there is no difference made by the Constitution, now the Honorable Supreme Court has to apply its judicial wisdom to understand which right will prevail over the other. Right A, 19(1)(a), right to the candidates, right of the voters to know the information, that is on one side. Another side is right to privacy. Both are in conflict now. Now let us see the next question. Whether the measure is a suitable means for furthering right A and right B. So the adopted one is electoral bond scheme. Does it advance these rights or does it restrict the rights? C. whether the measure is least restrictive and equally effective to realize right A and right B. Whether is it creating a least restriction on the fundamental right or not. That is what the necessity stage is. Fourth is whether the same has a disproportionate impact on right A and right B. Whether is it disproportionate. What we have seen in the proportionality standard test, now it is a comparison between A and B with reference to the same principles. Legitimate goal, second is rational connection stage, third is necessity stage, fourth is balancing stage. Now in this double standard, because comparing both parties A and B, one side candidates, one side is political party, another side is voters, so balancing both. So how they have applied, how they are going to apply, how the Honorable Supreme Court has answered beautifully. And this is a classic example, dear friends. When a parliament legislature has come out with sort of electoral bond scheme and amendments in the various provisions, the Honorable Supreme Court has once again made a judicial review and struck down these provisions as unconstitutional. And for what? For letting the voters to know about the political party. So we the people of India, that is what the preamble is being reflected in every judgments like this. That is why it is a leading case law. So thank you so much, dear friends. Remaining things will follow in the next lecture. Thank you so much. Thank you. I am deeply obliged and I wish you a very happy Dashara. Let Durga Devi show us the right path of light and let us have a group photo, dear friends. Thank you.